I think I'd call this the third last home stretch. I mean, you know where, the tape is, and you are perhaps, quarterly done. So, for perhaps 60-kilometer race or marathon, you're quarterly done. And given that we have 2 weeks, 2 weeks, yeah, because I think your also began on 1st of November. Yeah, so we're almost at the tape. It's a home stretch. So the home stretch will come in the last week. I think that will be on the 30th of October, which is on a Saturday. Yeah, so what we're here to do is to, I don't know, to polish up, to palate, the food. So it's upon you to either throw it away or you consume it. Can you hear me? I think it was muted or something.
Yes, we can hear you now. Yes, we can hear you.
Okay, so I was saying what you're here to do right now. You have 3 weeks to go, so it's you're almost passing over the baton. So what you're trying to do is to polish up, to try and sharpen, the iron, and make it quite functional. So whatever we have in store for us, Sri Lanka, Alex, Noah, and I think that will be enough. At least it is more than the 3/4, you'd expect. So yeah, I'm looking forward towards towards better performances from all of you. I think you're equal to the task, and just do yourself proud. And like Alex mentioned, if you don't really get to perhaps achieve what you aimed at, don't feel bad. Don't feel bad, because at the end of the day, it's the big exams and the projects that you have control over. So yeah, this is just a surplus. I think we have given everything about us, so we are almost becoming empty, because we've given everything that we thought was quite useful to each and every one of you, be it here through this Microsoft Teams or through our engagements on WhatsApp and other platforms. So yeah, what's remaining is just to take it home. So yeah, so long, I think with that, I'd like to rest my case. Thanks.
Thanks a lot, Alex. Thanks a lot, Lavin. Sorry. Now I think Noah is also in. Maybe he can also introduce himself. Then I will begin immediately. Noah, are you in?
Yes, I'm in.
Thanks.
So good evening. I hope you can hear me. Now, just to back up what Solonka said, Miss Purity, I realized I heard you say you panic. People do panic, and I'll give you just a short story.
Yes, I'm scared.
Okay.
Kinda.
So it's a normal thing. I'll give you a short story. When I was applying for my pupillage here in Kisumu, I did it virtually. So I realized that the farm owner never interviewed me. It was the associate. So when I first landed, I found there was this advocate, the youngest. And nikamuuliza, why did this man not interview me? So he directed me to go to YouTube and check a clip of something that happened to him. So when I went to YouTube, I realized that this guy was applying for the position of. There was a time when ELC was conducting interview. Sorry, the JSC. So he applied for the Environment and Land Court judge position. So when I was listening to the recording in YouTube, what happened is that this guy was praised. He wrote a lot of good submissions in Alipeleka huko. I understood the Muratetu case, matters of arbitration. So something funny, it was time for Mr. Majanja, who was also, Justice Majanja, who was also his classmate, asked him just a simple question that completely threw him off. So Mr. Majanja, the first question he asked, Justice Majanja, the first question he asked him was, who is Bobi Wine? What is the real name of Bobi Wine? And what I saw, that guy completely froze. Imagine you are from discussing issues of arbitration, umetoka mambo ya jurisdiction, sijui Muruatetu, sijui nini, and then somebody from somewhere is coming and then asking you, who is Bobi Wine? So it completely threw him off. He panicked. Napo by then ndio sasa mambo ilimwaribikia, igeuzia. So security, it happens. So the question is, how will you now recover? And I'll tell you, even me, when I appeared before Mossa started with the issue of before repeal laws and PSR, 2 amended laws. I'm telling you, you can recover. You can recover those marks and still scoop them on. So do not panic. Usiende nje ya ambulance. Just be confident. Come ujui, just say that those that you know, and you'll be good to go. But do not panic to the extent that zile maswali next unaulizwa zinakushtua. So that's all. Panicking is there. Professors panic, students panic, but it's how they recover when they are asked questions. So Miss Purity, usijali, hiyo ni maisha. Whatever you get from the orals, just embrace it. I have a friend who got 10. Kuna mwingine alipata 8 from my university. A lady alipata 8 orals, the same panel that my friend Kamau also who got a 10, and they both got their 9 Ps. So whatever you get, whether 10, 7, 18, when there's always another chance called the by exams. You can ace it. That's what I can tell you. Do not worry.
Thank you so much.
Yes.
Yeah. Okay, thanks a lot. Now we'll begin with the orals immediately. Thanks a lot, Noah, for that. Thanks, Lavins. Thank you, Alex. Is anybody else that I'm locking in? I'm locking out.
No, could you please share the video that you watched, please? It will come in handy.
Yeah. Oh, well, yeah, that's actually what I said is actually where. So you saw even in the Supreme Court, in the Supreme, the JSC interviews for the judges of the Supreme Court for the position of Chief Justice. There were serious legal minds over there who found it challenging to answer some questions. So don't be discouraged or anything. So kindly let us have volunteers so that we may begin with the orals session. Who wants to volunteer before we pick? You know, and then remember, this is how you become better. You know, practicing and practicing. See, your hand is up. Okay. Muturi Andrew, this Kabaila Nina. Oh, thank you. So I think let's begin with Nina, then we go to Muturi. Nina, are you ready?
Yes. Hi, I guess I am.
Okay. No, you are ready. Don't worry. So maybe for you, I'll start with Alex. Alex hasn't been here for a few weeks, so we can begin with Alex, and I would like to give my colleague Alex the first chance. Singing, Alex, go on. Okay. Ask, and then I'll ask her. I'll follow up.
Is it Nina?
Yes, Alex.
Hello, Nina.
Hi, Nina. Okay, Alex can proceed. It's Nina. Her hand is up.
She's on mute. Hi, Nina.
Oh, hi.
Okay. I'm Alex, so I'm just going to ask you just a few questions, and then we can discuss afterwards on your performance. Okay, let's start.
Okay.
The first question is, what is the law in Kenya which governs use of movable property?
I'm sorry. You are not quite clear. I'm not sure whether that is on my end.
There's so much noise on the background. I don't know if it's from your
Okay.
end or as well. Can you hear me now?
Yeah, now it's clear.
Okay. So my first question was, which law governs use of debt? Use of movable property to secure debts in Kenya.
Thank you very much for the question. Now, when you're discussing the law that relates to movable property in Kenya, the one that comes to the top of my head is the Movable Property Security Rights Act of 2017. And the act specifically states that it is the act that has been enacted for the purposes of enlarging or giving a wide array of the type of assets that can be used as collateral, in this case, movable property. So the MPSR under Section 4 specifically states that it has been created for that purpose. And it's for the purpose of creating, it gives the process of creating perfection of such movable property security rights. And to be able to secure these rights as well, you also have to look at Section 6 of the MPSR, that's the Movable Property Security Rights Act, which talks about the creation of a security agreement, which through the said security agreement is how you go through the process of perfecting using movable property as assets. Thank you.
Thank you for your comprehensive response. Just a follow-up question. Give me two types of movable property which the act does not apply.
Okay, the Act under Section 9, if I'm not wrong, talks about, between Section 8 and 9, talks about the property which it does not touch on. And one of the properties that I can generally state is the properties that have been provided under other acts. For example, if you talk about things like, let's say, land is generally covered under the land laws of 2012. So in this case, you cannot bring the MPSR to govern such assets under it. Thank you.
Thank you for that response. My second question is, what was the legal principle which was developed in the case of, Raylands versus Fletcher?
Thank you very much for the question. When you talk about the case of Raylands versus Fletcher, the thing that it touches on the most is the issue of strict liability. Now, strict liability in this case, I'm going to talk about what it talks about. It's where you generally do something that amounts to a tort, which generally offends someone else, but then you're not the one who has initiated such an activity. If we look at the facts of the case, the defendant in this case had contracted workers to come and work on his land. And in the process of the other workers working on his land, I think it was water or soil that moved to the plaintiff's portion of land. So when the plaintiff moved to court, the defendant obviously said it was not his actions that amounted to what led to, the actions of detriment that were faced by the plaintiff. He said that he was not the one who was capable for it. But then it was held, the court held that the actions were actually actions of strict liability, and to some extent he was liable for the same. That is all.
Okay, thanks for that response. You have captured the rationale and even the facts very well. My final question would be: you are aware that the Court of Appeal has in the last 2 weeks rendered a judgment on the issue of timelines in procurement matters. Could you be familiar with what the Court of Appeal has said in that recent decision?
Thank you for the question. If the member of this panel would be kind enough to excuse me for the same, or probably issue me with a follow-up question, as I am not well versed with the facts of whatever was going on in that matter. So if I could kindly be pardoned on the same.
Okay, thanks. That's my final question. I think someone else can ask something.
Thank you, Nina. Now, my first question will be, what's the difference between a default judgment and a summary judgment?
Thank you very much for the question. Now, before I delve into the difference between a default judgment and a summary judgment, we'll first look at how it comes about in the first place. So when the plaintiff has filed his documents and he's actually satisfied to the court that he's done proper service to the defendant, and the defendant has not entered appearance or filed any documents to aid his case, then the defendant can move for either a summary judgment or an interlocutory judgment. In this case, though, the question that you asked is default judgment or summary judgment. Now, according to me, there's really no difference between the two terms. And when you're looking at the definition of that, we can look at Order 10 and Order 36, which specifically states that where the defendant fails to enter appearance or file a defense, the plaintiff, after satisfying the court that he has served he's done proper service to the defendant, can come for a summary judgment if the claims under the plaint contains liquidated amount. Now, when you're talking about a liquidated amount, is an amount that is specifically stated, something like something like special damages, something that has been quantified. Now you can move for a summary judgment in this case, or a default judgment. But where the plaint does not talk about the exact liquidated sums, then you can file for an interlocutory judgment, still under Order 10 from about Rule 4 to 5. Thank you.
Thank you for that. My follow-up question will be, what's the difference between an admission and a confession?
Thank you for the question. If this panel would be kind enough to let me espouse the little knowledge that I have on the same. But according to me, when you're talking about admissions and confessions, those are just ways in which one can attack a plaint. So basically, yeah, generally just they're just different ways in which you can attack a plaint. So with admission, you just admit the extent of liability as conferred by the plaintiff in the plaint. So probably if the plaintiff states in the plaint that there was a contract between the two of you, and then you come up with a defense stating that you admit the contents of such and such a paragraph, which subsequently stated that there was a contract between the two of you. Now, if you contain such a clause in your defense, that means you're admitting to the same. But generally, the two of them are ways in which one can attack a plaint. That is all.
Okay, thank you. Now, that is in regards maybe to civil. What of criminal litigation? Oh no, not criminal or civil, but according to the Evidence Act, what's the difference between a confession and an admission?
Okay, thank you for the question. according to the Evidence Act, I wouldn't really say there is a, okay, there is a difference between the two, because I'd say when you're pleading, when after charges have been read upon an accused person and you want to plead to the same, pleading is, according to me, I would consider it a form of an admission. Now, when you're talking about confessions, it's just a confession of guilt on part of the accused person. This is after the charges have been read to you, and you feel like you want to come out clean, for lack of better words. So in this case, the accused person can come and just confess to the crimes that they have done. But then upon giving confessions, one has to be very clear, because, give me a minute. Sorry for the interruption. So,
It's okay.
okay. So when you're confessing, you have to be very aware of your rights, because you don't have to give such confessions under coercion, as has been protected under Article 49 and 50. So the court also has to be wary of the same. And generally, I can say those are the rules governing confessions.
Okay, thank you so much for that. Thank you so much for that. Now, have you learned about judicial review?
Pardon?
Have you studied judicial review in your class?
Not yet.
Okay, that's fine. Okay, that will be my last question. Now, we'll give you your reviews. Alex will begin, then now I'll give you my reviews. But in brief, you've done well. You're confident, you're audible, you're clear, and yeah, I'm impressed. So Alex will begin giving you his remarks, and then I'll follow up with mine.
Okay.
Hi, Nina. I think you have done really well. I've liked your approach to answering questions. You have been comprehensive, but then you have also you have not talked like so long such that you lose the audience. So when you're asked a question, try to balance. Answer the question comprehensively, but then don't talk too much so as it appears like you want to evade other questions. So I think you have it's a tricky balance, but I think you are managing and you have done well.
Okay.
I also like the way you are addressing your questions in. You see that there's a way we call this using you see when you answer, you are asked a question, you start by saying and then you see I don't know, I don't remember the phrase which you used to describe that, but you are not using that, which is really good. When you are addressing the audience, try to be smooth, try not to appear like you are not so sure what you're talking about, and of course you will impress the panel. And on the questions, the first thing I've noticed is you have tried to answer all the questions, which is good. And also there are questions which you are not sure, which you have just passed, which I admire, because I said this some time back. If you are asked some questions, if you are asked I do not know, just say you don't know. That's my personal opinion, because you might end up answering a question which you don't know the answer, and then you end up looking dumb because the panel looks at you and they think you don't really know what you are saying. A good example is the last question which I've asked. It's a Court of Appeal decision which was rendered, I think, last week, but on 8th October. It's a procurement. It was a procurement dispute. The issue was the timelines in procurement. Usually, when you have a dispute or you have a grievance with regard to a decision by a government body with regard to a procurement matter, the first court of recourse is usually the first dispute resolution mechanism to resolve your dispute is the procurement board. I think it's called the Public Procurement and Review Board, something like that. If you are not satisfied, even if the party is not satisfied with the decision of this review board, they usually appeal to the High Court, I think within 14 days. When you look at Section 77 of the Public Procurement and Asset Disposal Act, it talks about the timelines. But now, the trick is when you get to the High Court, that act, the Procurement Act, states that the High Court must make a determination on that dispute within a period of 45 days. So what happened in this case is the High Court failed to make a determination within a period of 14 days, but it went on and found that it had jurisdiction to make make a judgment nonetheless. So one of the party who lost appealed to the Court of Appeal, and the issue was whether the High Court could render a judgment after the 45 days. And the Court of Appeal has said no. Once the 45 days have lapsed, the High Court lacks jurisdiction. But then the Court of Appeal rules, actually the decision of the Court of Appeal was rendered, the Court of Appeal is not, is also bound by those timelines, but then the Court of Appeal rules, Rule 35, allows the Court of Appeal to make a decision on an issue and then give reasons later. So the Court of Appeal made its decision in around March, but they did not give its reasons for that decision. So in a judgment relevant last week, but one, the Court of Appeal gave reasons for its decision. The Court of Appeal argued that it gave its judgment within the statutory timelines under the Procurement Act. So this is a judgment which has been discussed online. And the reason I asked you about this judgment is because I was asked a similar question during orals. You see, these judgments which you see moving around at this time on LinkedIn, on Facebook, you see people talking about some judgment somewhere which has been rendered. There's this judgment about minimum tax which has just been rendered by the court. There's this judgment from last week which has declared MCS that it has the judgment is to the effect that MCS will not be required to have degrees to contest in next year's election. These emerging legal issues, you can be asked them during orals. So in a position to respond to such a question, instead of you responding to such a question and then appearing like you don't know what you are doing. Another thing that I've noted is your use of sections. When you are asked a question and you are not so sure about the particular section which talks to the answer which you want to say, just say that you just give the actual answer but avoid saying the section. You can even say the act, but if you say the wrong section and the panelist seems to, or it happens that they know the section, they might use that against you. Don't give people room to take advantage of your situation and put you in a bad position. I say this because of your question on the MPSR Act. I think it is Section 4, not Section 8 or 9, which says movable properties which the Act does not apply to. One of them is the ships. And I said this, there's a time I asked this question some time back. The MPSR does not apply to ships. It does not apply to aeroplanes under when you look at Section 4, you'll see it does not apply to shares in the it's called the Central Depository System, CDS accounts. It does not apply to. There are like 4 things which the MPSR Act, there are 4 movables which the MPSR does not apply to. So if you know the answer, just say the answer instead of going to a section if you're not sure about the section. Finally, there is the question I asked you about Freelance versus Fletcher. I think you answered it really well, because you see, when you are asked a question, there's a way you answer, and you just answer the question without even going into too much detail and confusing the panelists. For example, if you are asked, what is the principle in the case of Freelance versus Fletcher? You know, the principle is strict liability. Everything you say after that, once you tell me the strict liability is what came out of that case, as a panelist or not, listen to the other stories. I'll just tell myself these students know what they are doing. When you are asked the case of Donoghue versus Stevenson, duty of care, when you just say the main principle from this case was the duty of care, and then you go and give your stories, you already answered the question, And I believe the panel will be the panelists will be like, oh, this. So use those buzzwords. If you find a buzzword which best describes the answer which the question relates to, apply it, and of course you will excel. I think that's all from me. I hope you have benefited from my feedback, and I think you are doing well, and I hope I think you are ready, and I hope you'll do well. Thanks.
I have. Thank you very much.
Thank you very much, Alex, for that. Now, Nina, on to me. You did perfectly well. You answered the questions very well. Your grasp of the law is also to be commended, and that's a good thing. So, on the first question, to do with the summary judgment and intellectual judgment. So, if you appear before Mrs. Mongari, there is a question that she loves, and I'm not sure if she's taught this in class, but I'm sure she has taught it in class at this stage. I think she's really emphasized on summary judgment, default judgment. Even in class, she has the habit of, before the class begins, to ask somebody, what's the difference between a summary judgment and intellectual judgment? So if you appear before her, there's a 95% chance you will be asked such a question. So what's the difference between a summary judgment and an intellectual judgment? We first begin with the statutory provision. Intellectual judgments are found under, or intellectual or default judgments, are found under Order 10 of the Civil Procedure Rules, which you rightly pointed out. And summary judgment is found under Order 36 of the Civil Procedure Rules. Now, the main difference between the two, actually, I can say two differences. The first one is, in default judgments, this is where no appearance has been entered and no defense has been entered. Okay. No appearance has been entered and no defense has been entered. If you check the wording of Order 10 of the Civil Procedure Rules. Under Order 36, which is on summary judgment, it talks about where the defendant has appeared. So he has entered appearance, but not filed a defense. So that's one difference. In summary judgments, you've entered appearance, but no defense has been filed. Whereas in default judgments, no appearance has been entered and no defense has been filed. That's the first difference. The other difference will be with regards to, and these I'm just expounding it in case you ask, with regards to the documents that will be filed in the appropriate circumstance. In default judgment, you need to distinguish. This is where there's a liquidated demand and unliquidated demand. So if there's a liquidated demand, or if judgment is upon a liquidated demand, then the document that will be filed in court will be form number 13 of Appendix A of the Civil Procedure Rules. Form number 13 of Appendix A of the Civil Procedure Rules. And in summary judgments, the document that will be filed in court, or the application that will be filed in court, is a notice of motion supported by a supporting affidavit. Okay. That's another difference. So I hope you've grasped that. And then maybe another thing that will be asked. So in default judgments, if it's a liquidated demand, you just do the application under form number 13 of Appendix A. And for any unliquidated demand, the matter has to go for formal proof. This is just a hearing to ascertain what is supposed to be owed. Okay. That's the difference between a summary judgment and an intellectual judgment. Now let's go on to the next thing which I asked, which was the difference between an admission and a confession. And the provisions for that are found under the Evidence Act. The Evidence Act, which provides for what an admission is and what a confession is. In simple terms, when you're talking about confessions, this is when it's like you're inferring guilt. Yeah. When you make a confession, these are words or conduct that may be taken, and they infer whether you have committed a crime or whether you have not committed a crime. Okay, not a crime per se, but an offense, whether you've committed an offense or not. That's a confession. Words or conduct that can infer commission of an offense. Whereas when you talk about admissions, it's basically statements which infer, now in this circumstance, which infer they talk about any particular fact. So to put it in better terms, have you admitted to a certain fact? Yeah. Have you admitted to a fact? But when you talk about confessions, have you committed that offense? Have you confessed to this offense? That's the main difference. Now, to find the wording, the appropriate wording, go check section 17 of the Evidence Act, which talks about admissions, and section 25 of the Evidence Act, which talks about confessions. So admissions, they relate to certain facts. So they basically inferences on a facting issue or any relevant fact. Confessions, they refer to whether you've committed an offense or not. And then you can maybe expound more if you ask such a question on, there's the out of court confession rules, how a confession is admissible. For it to be admissible, for the evidence or for a confession to be admissible, what should happen, what procedures should be followed, and so forth. Those are the two main questions they asked, and they are pretty famous questions which you will get in your orals panel. Now, I didn't ask a lot of questions so that we get room for other people to join in and participate. But I have so many questions which are popular questions which you won't miss in one or two of your oral panels. So thank you, Nina. You did very well. Congratulations. You really, really perform well in your oral exams. Now, who was the next?
Thank you.
Welcome. The next volunteer. Who's the next volunteer? Then Noah and Lavins can take them through. Who wants to volunteer next? Muturi's hand was up. Muturi, are you in? Okay. Mwangi, I'm seeing a hand. Mwangi John. Okay, thank you for that. Mwangi, are you in?
Perhaps you could just go with Muturi.
His hand is actually not up.
Okay.
It's not up.
Fair. I can take a try.
No problem. Thank you so much. Lavins and who? Lavins and
Awesome. Thank you. Yeah, so Mwangi, how are you?
I'm good. Evening to you. Evening to my esteemed colleagues as well. I hope you're great as well.
I'm great, thank you. How are you feeling?
A bit anxious. I hope it's not coming through. But all in all, I'm okay.
All right, so here we go. Okay, so you are a magistrate, okay? Are we together up to that point?
Yes.
Thank you. An accused person charged with murder is brought before you. What will you do? I repeat, you are a magistrate. An accused person charged with murder is brought before you. What will you do?
So thank you so much for your question. So one of the preliminary issues that one would need to think about as you're walking into a murder case, as a magistrate or as a judicial officer, is that one must recognize that murder is a capital offense. So the first thing one would need to find out is from the accused, as at the point when they're taking plea, is on this issue of availability of counsel, which is actually quite important on matters murder, on matters capital offenses. Point number two, one would also need to ascertain the capacity of the accused, primarily because as we're already noting that murder is a capital offense. So as at the point when the accused is brought in front of you, you need to ascertain that they are of good or they have good mental capacity. The last thing is a question of jurisdiction. You must recall that even with you being a magistrate, not all magistrates can handle murder cases, primarily because questions of murder are of a grievous nature. So as a magistrate, you want to ascertain to yourself that you have the requisite jurisdiction to handle such a matter. And I think for me, those are the top three things that come to my mind as a judicial officer, as at the point when I'm handling a case on murder.
All right, thank you. My second question, distinguish between assault and battery.
So while I'm unable to give you a proper definition, at least one that is based on the code itself, I can address this panel on two respects. Number one, when you think about this crime of the crime of battery, battery usually must always be accompanied with a physical action. You know, it must be accompanied with some sort of force, some sort of physical action. However, assault, on the other hand, does not necessarily needs to be accompanied with a physical or a forceful action. So if I could just give an example, we have cases that have been decided that when you make a call and you stay silent for the purposes of intimidating somebody, then that falls within the requisite criteria for assault. However, that will not meet the criteria for battery, because in battery, there needs to be some sort of force that is meted out by one person to the other person.
Right. My third question. Okay. So what's the difference between a surety and a recognizance? I repeat, what's the difference between a surety and recognizance?
I am unable to address this tribunal on the specifics of both. However, if I could make an intelligent guess, just based on the knowledge that I have on top of my mind, a surety is usually given, rather, maybe as a point of beginning. Both the surety and the recognizance are usually ways by which an accused person can secure their release as the trial is going on. Now, when we speak about a surety is usually like a sum or a property of a certain value that is given to the court, that is submitted to the jurisdiction of the court for purposes of making sure that the accused person is not going to abscond trial, but rather the accused person is going to subject himself to the motions of trial. Now, this is substantially different from recognizance, because a recognizance is given on the personal guarantee, is given on the person himself, but it's given on the, for lack of a better word, on the integrity, based on the integrity of the accused person himself. So it's different from the surety, because in the recognizance, the accused person is not required to submit anything, any sum or property of a certain value. Rather, he is allowed to live. He's allowed to go and attend trial, because the accused in and of himself is considered to be a person of integrity, or a person who will not abscond trial. So that is the fundamental difference between a surety and a recognizance.
Right, my fourth and second last question. What do we mean by duplicity of charges, and how does duplicity of charges occur? I repeat, what do we mean by duplicity of charges, and how does duplicity of charges occur?
So duplicity of charges is a situation that occurs when in a count we see more than one offense. So, for example, if myself, John, I have committed a crime, and in the commission of that crime, in the transaction of that crime, we have two separate offenses. So, for example, if on my way in I broke into a house, and then I went and upon breaking into a house, I found residents inside that house and then robbed them at gunpoint. So we have two cognizable offenses there. We have the offense of robbery with violence, and we probably also have the offense of burglary. So if those two offenses are charged under the same count, then what will be occurring there is the duplicity of charges. So what ultimately should happen is that those two separate cognizable offenses should each be charged in a separate count. And so that is what duplicity of charges means, and that is how it occurs.
My last question. Give me 5 different types of immunity. I repeat, give me 5 different types of immunity.
So thank you so much for this question. So we do have various types of immunities, and when you think about immunity, it is a way by which an accused person or a person who has been granted this immunity is sort of allowed to quote unquote be let off the hook because of the immunity that is bestowed on the said person. So the first immunity that comes on top of my mind, this is an immunity that was recently litigated on, is the presidential immunity. And when we speak about the presidential immunity, we are saying, as at the point when a sitting president or a president of the Republic of Kenya is sitting in office, then that president is immune, is said to be immune. Is said to be immune. Is said to be immune as at the point when they're carrying out the functions of the state. Now, number two, we have the kind of immunity that is meted out on ambassadors, and this immunity allows ambassadors is bestowed on ambassadors of different countries who are working in this country. Now, we also have an immunity that is meted out on a sitting governor. We also have an immunity that is meted out on sitting judges. And the immunity for sitting judges is that they are immune from actions that they have done in the commission of their judicial functions, and those actions must have been done in good faith. So those are some of the types of immunities that are available under the law in Kenya.
Thank you. No further questions. So Noah Raider, please take over.
Yes, Mr. John, good evening.
Good evening to you.
Yes, my first question is, kindly name highlight 4 completion documents under conveyance.
Thank you so much for that question. So when we speak about completion documents are those set of documents that are absolutely necessary for purposes of wrapping up and transferring an interest in property from the seller or the vendor to the purchaser or the buyer. So one of the completion documents that one requires, number one, is the title document. That is the title to the property itself. Number two, we also have the transfer instrument. That is the document that is supposed to do the transfer from one party to the other. Then we would also require the details of the vendor, and you'd also require the details of the buyer. So those are just some of the completion documents that are absolutely necessary for purposes of conveying property from the vendor to the buyer.
Okay, my second question is, What is the difference between a test suit and a representative suit?
Thank you once again for that for that question. So when one speaks about a test suit, now a test suit is a suit in which the findings that are made on the test suit itself can be used for purposes of that is the findings can be then transposed to the other suits that are of a similar nature. That is, they have more or less they more or less have similar facts. And then a representative suit must be a suit must be a suit akin to a class action. So that is a suit that is being done for the purposes of getting, for example, damages or all the remedies that are available under a law for purposes of allow me to take that again. When we speak about a representative suit, the goals and aspirations of a representative suit is to get findings in one suit on behalf of very many people, and that to me is the fundamental difference between the test suit and the representative suit.
Okay, my final question. It's an application question, so this is it. Noah, bought land from one Brian Solonka in 1981. Then I paid it, and then what happened? Before the transaction was complete, the transfer, Mr. Solonka has gone. What happened?
I think you need to be unmute to unmute. Somebody
No,
muted.
Oh, sorry. My last question is, it's an application question, sorry. So this is what happened. I bought land from one Pareno Solonka. I hope I'm clear now. Eh?
Yes, you're coming in loud and clear.
Okay, I bought land in 1981 from one brand Solonka. Eh? So I bought the land, paid him the sum, let's say 5,000. During those days, land was a bit cheap. And then, unfortunately, somebody's muting me. I don't know who is muting me. Solonka, kuna mtu animute zote.
Yeah, apologies. But kindly refrain if you're doing that.
Just allow me to ask.
Go on now.
Allow me to ask me, Mr. John, the question, and then you can mute me. So, Solonka sold me a piece of land in 1981. Then
What's happening? No, you're muted.
yes, I am.
I just want to say it's not me for the record, just in case.
Hey, kindly, if you are the one with the, with our tendency and propensity of muting people, please just kindly refrain. It doesn't reflect who we are as, lawyers, and this is a noble profession. So kindly don't do that, please. Thank you. Now I'll proceed.
Okay, let me ask my last question. I bought land from Solonka.
I don't think it is somebody who is
It's a
muting.
technical glitch on your part.
It could be a challenge with the team. Probably you can log in and log in.
No. Check your internet connectivity. Noah. I don't know how authentic
back.
that argument stands, but you can just proceed. I don't know, like why your mic is is muted. Solonka, I think he has issues.
Yeah,
So
maybe
perhaps you join and then we could pick it up. Yeah, sure. I could proceed perhaps
That's
just
fine.
giving my feedback before
Yes,
Noah
yes,
gets.
go on.
Thank you. So Mwangi, I think so I'll begin with the last question I asked you on the different types of immunity. So what you mentioned as presidential immunity is always classified under what we call sovereign immunity. So in sovereign immunity, the prevention of lawsuits, or prosecutions against rulers or governments without their consent is covered under that particular category. When you look at Article 143 of the Constitution, it makes the president, immune from any legal proceedings during the tenure of his or office. So the immunity, shall, however, not extend to prosecution from crimes under any
Lavins, you're mute. Lavins, you're mute.
Can you hear me?
Yes, can hear you now.
What is the last thing I said?
You were speaking about sovereign immunity and the Constitution.
It's someone muting me, and it's quite sympathetic behavior. I don't know who is doing that. So
Solonka, Lavins,
yes.
I think
Yes.
the person who convened the meeting, whether Solonka, the person who convened the meeting, they should change the settings such that the
Let me do
only
that.
the convener can mute somebody. You can change the settings in your on because definitely there must be someone who is muting other people.
Yeah, there is, and it's quite some unfortunate, behavior. Let me try. Just a minute. I think let me try that. I hope it has reflected. It's okay. So back to what I was saying. I stopped at prosecution on crimes against humanity. I think that's where I am. So okay. So I said Article 143, makes the president himself immune from any legal proceedings, during his or her tenure in office, but that immunity shall never extend to prosecution from crimes under any treaty to which Kenya itself is a party. The other type of immunity is the diplomatic immunity. You called it, ambassadorial immunity, but it's not a diplomatic immunity, which is still correct. So here, the argument between sovereign governments to exclude diplomats from the local laws. And then the third type of immunity, we have immunity from prosecution. So this is basically granted to a witness in exchange for testimony. Then the fourth type of immunity, we have immunity from prosecution under international law. That is, the exclusion of all governments or the officials, from prosecution under international law. And then we have the last, or the second last, actually the sixth. The second last is the judicial immunity. This is the immunity of a judge or magistrate during their tenure and in the course of their duties. So we call that security of tenure. So it was quite a subject of debate, why judges should be subjected to, unnecessary litigious processes in court. Yet, the members of parliament who have that immunity courtesy of, the parliamentary powers and privileges, wouldn't be subjected to such, atrocious or sinister actions. And then the last type of immunity, we have the state immunity. So here, the government of a state is not amenable before the courts of another state. So the other question that I asked you was a question to do with you are a magistrate, and an accused person charged with murder is brought before you. So what would you do? You see, this is a trap. This is a trap. And you started well by mentioning, something to do with preliminary, objection or something. Yes, you did mention that. In other words, I thought you'd keep up with that particular momentum, but then you deviated, you went out of topic, and then you picked up, I think, at the last, moment. So in other words, what you will do as a magistrate is you will not, cannot, and will never proceed with the matter. Reason being, you have no jurisdiction to deal with murder cases. So it's not the question about, you have certain types of magistrate courts that deal with murder cases. No, it doesn't, work like that. Magistrate courts don't have exclusive jurisdiction to hear murder cases. So in other words, I just wanted you to say, this matter will not be heard by you because murder cases are the exclusive jurisdiction of the High Court. So since the High Court has unlimited, original jurisdiction, it can hear any case, be it, traffic or others. But there are some, cases which are exclusively triable by the High Court. And one of these cases are murder. The other one is treason. So these two cannot, be tried in the subordinate courts. The subordinate courts can, however, try manslaughter, but not murder or treason type of cases. So the chief magistrate, to senior resident magistrate, which is the last court in the hierarchical structure of courts in the country, they have the jurisdiction to grant the death penalty. That one they have. The other lower, courts have jurisdiction of a maximum, let's say, of 7 years imprisonment, while I think it doesn't exist today, but there used to be what we call the district, magistrate courts, that have the jurisdiction of 2 years in imprisonment and what have you. So, like, the resident magistrate itself cannot entertain, a plea regarding robbery, with violence, which carries basically a death sentence. So it will be subjected to the other, level of courts under the subordinate courts. So the other question that I asked you was the difference between a surety and a recognizance. So, yeah, you tried, responding to that, but the response will be, when it comes to surety, it is a person who promises to forfeit, to forfeit a certain, sum of money fixed by a court. When it comes to recognizance, it is the status. It is the status of a surety where the accused person fails, to attend court as and when required. Then the other question that I asked you, I think it was the second last question, what's the difference between assault and battery? Yeah, you fairly tried. So when it comes to assault, it is an act, which causes reasonable apprehension of the infliction of violence against another person. So no physical contact, is actually required. So the emphasis, is on the response of the victim. So if it does cause the person to become scared or some sort of apprehension of violence, then this is assault. When it comes to battery, this is where force is used intentionally without the person's consent. Okay, so that's the difference that I actually wanted you to bring out. And then the last question that I asked you was about was it duplicity? Yeah. So I asked you, what do we mean by duplicity of charges? And how does it occur? So duplicity of charges, yes, you tried, you did okay, but on emphasis, I'd say duplicity of charges is the joining of two or more offenses in the same count of an indictment, okay? So it is a legal requirement that a charge should not suffer from duplicity. It will make it defective charge sheet, okay? So duplicity occurs, where the charge or count charges of the accused of having committed two or more separate offenses. Okay, so that's the meaning of duplicity of charges, and duplicity can be avoided where a statute creates offenses in the alternative. For example, when you look at section 86 of the Traffic Act, it does provide for offenses created in the alternative. For example, you have causing death by driving a motor vehicle, driving recklessly, driving at high speed, driving in a manner dangerous to the public, leaving the motor vehicle on the road in a manner rather that is quite dangerous to the public. So all these are alternatives, meant to avoid one from being charged of two or more, but only one of the alternatives.
Thank you, Lavins. Are you done, Lavins? Okay, it seems like we've lost him. No, are you back?
Yes, I'm back.
Okay, now you can complete then.
Mr. John, I only had one question left. Sorry for the interruption. My question was, suppose I bought land, me being the purchaser, from one Pareno Solonka in 1981. However, due to the normal acts of God, before we both pass on before the transfer is completed. So my daughter has been living in that land since 1981 to 2021. However, Mr. Solonka's daughter comes and start erecting buildings. They want to chase away my daughter from that particular land. So my daughter being aggrieved, remember me and Solonka, we are both late. So my daughter being aggrieved comes to you as a legal expert and an advocate of the High Court of Kenya. So my question is, how will you remedy my situation, my daughter's situation, sorry?
Thank you so much for your question. So if I get the question right, your daughter is the one who is approaching the court?
Yes, he is
Okay.
now she's the complainant.
Okay. So just based on the facts that you've provided us, your daughter has been in possession for on the piece of property that is from 1981 to 2021. So we're talking about roughly 42 years. And one of the things that is glaring from just that set of facts is that no matter what one would think about the initial transaction that was happening, there is a plausible claim here for adverse possession, precisely because Noah's daughter has been in quiet possession for more than 7 years, which is the minimum amount of years that you need for purposes of getting possession. Now that's one of the points that one needs to note. Now the second point that one would need to note is that it is the evidential question. Seeing that both the vendor and the seller are dead, and well, the facts were silent on whether or not there was a written agreement to that effect, then then the evidential question would then become, more apparent and a bit more glaring on that front, because if both the vendor and the purchaser are dead, and there is no written agreement to that effect, then as at the point when Noah's daughter is trying to enforce, if she wants to enforce the initial agreement, then it becomes absurdly hard, especially considering that the Law of Contract Act requires that all agreements must be done in writing. So I'd say if Noah's daughter has approached the court, then her best claim must be a claim under adverse possession, and that's a claim that Noah's daughter is most likely going to succeed on.
Okay, just a question. You have left certain things out. Which court are we going to approach?
Oh, my apologies. When it comes to land questions, the original jurisdiction lies with the ELC, the ELC court. So that is your first point of call. But one must also note that since the land was valued at 5,000, then one would want to get a proper valuation, a current market value valuation, for purposes of establishing what court would have the requisite jurisdiction. Seeing that in as much as original jurisdiction lies with the ELC court, we have subordinate courts that can have requisite jurisdiction depending on the pecuniary value of the matter. Now, the 5,000 here might be slightly misleading because it is a 1981 valuation. So one would probably want to get a current valuation, and which is actually the valuation that Noah's daughter would be relying on, as at the point when she's launching a claim.
The pleading, before I make my comment.
So the appropriate pleading in this instance ought to be a plaint. Ought to be a plaint.
Okay, fair enough. I'll make my comment.
Yeah.
The last question that I asked, when you are claiming adverse possession, you don't need to allow. The elements are, and you go and read the Latin maxim of nec vic nec precario, which means neither by force nor secretly and without permission. So those are the brief elements of adverse possession. Now, what happens, and I'll refer you to the case of two cases. We have one of Selina Mudhoni Kidhinji versus Safia Binti Swaleh and 8 others. And then I hope you got the case correctly, the citation. And you also have the case of Wilson Njoroge Kamau versus Nganga Musheru Kamau. Now, what happened? The cases are similar to that application question I gave you. They both entered it as a purchase and sale of land agreement. They both, I think, with regard to Kamau's case, the parties passed on. So my advice is that what you do, you'll have to move to the High Court, and I agree with you, under adverse possession. Then the year limitation period is always very important. It's not 7, it's a 12-year limitation period, which of course in our scenario it has sufficed. Go and read the Limitation of Actions Act, section 17 and 7. 7 and 17, which provides for a 12-year limitation for adverse possession. And then when you read also section 37, it says that given that that land is registered in the name of the seller, then that seller usually holds it in trust for the adverse possessor until he obtains a vesting order from the High Court. So the seller, the parent to who? To the pareno will just be holding that title in trust for my daughter. So what happens, my daughter will now have to go to the High Court and make an application under adverse possession via an OS. It's not a plaint, it's an OS. So go and read Order 37. It provides for situations where OS are used. So what happens when you make an application under section 37 and 38, that is adverse possession, you have to make it by an originating someone. So it's always supported by an affidavit. And one thing that must be clear, you have to annex, not the contract, you annex the extract of the title to the land. So the title belonging to pareno, you must attach it behind that particular application. So the court will make a vesting order, which will now be sent to the lands where now the name of pareno will be struck out and my daughter's name will be placed. That's how adverse possession works. Now, where I asked about completion documents, I agree with you. Those are the completion documents. LSK condition of sale 8.4. Go and read it. And then lastly, I asked you about representative suit and test suit. And I'll give one scenario which will differentiate the two. Now, for instance, if we are living in a community, let's say KSL, and then KSL, let's say the lecturers, maybe they fire or they chase away students from school for whatever reasons they want to chase. So what happens with regards to representative suit? One student will be chosen among the rest. Then there will be, when you are moving the court with whatever pleading you wish, one thing that must be clear in those pleadings is the consent of all the others that you wish to represent